Perfect. Okay. So I'm here. We have Reba. We have Andrea. Yes, yes, yes. Let me know if you can hear me. And we're going to get started because we do 30 minutes, and I want to be respectful of everyone's time. Just let me know in the chat if you can hear me. There we go. Perfect. Everyone can hear me. Awesome sauce. And we're going to get started. Let's see. We have some great questions that are in. Hey, Josh, how are you? Let's see. I want to put this over here. And then I just want to make sure that we just have me as the speaker as far as the view. Speaker view. Yes. All right. Perfect. Let's jump into these questions. Hey, Stedman, nice to see you. Nice to see you. All right. So we got a few questions. And our first question, first of all, for those of you who are watching and and new to Murray's Law, this is your first time joining us. Hey, welcome. Glad to have you. I am Attorney Murray. Murray's Law is our live Q&A session where we answer questions. Nothing that we are telling you tonight is legal advice. It's information for educational purposes. Okay. And if you are new to me, I'm the owner of Off the Mark IP Solutions, where we help clients throughout the United States own their genius and protect their brands through trademarks, copyrights, and business development through our legal membership program, the Genius Insider. But that's enough about me because, again, we have 30 minutes, so we're going to jump into this first question. And the first questions we answer are going to be from those who pre-submitted it first, are going to be our Genius Insiders. We'll answer those questions first. And then if any of our Genius Lounge members, which is our free community, submitted questions, we'll answer those next. And then finally, if we have time, we'll answer questions directly from the audience that's watching. All right. So the first question is and I'm just going to read it out loud. Let's see. The first question is, with cybersecurity, where's it at? Boom, 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 boom. So with increased attention on cybersecurity, I'd like to know if you recommend adding a cybersecurity clause to independent contractor agreements when we're hiring vendors. So the issue is I want to work with a vendor to help me build out some infrastructure system for my business, but their contract doesn't speak to how they keep my information safe. I love this question, especially because there is a big issue around cybersecurity. And so what I would say to that is, whenever you're working with someone, the first thing you want to do is you want to ask questions, because it doesn't matter what's in the contract if you don't have an agreement on what it means. Because when you have the language in the contract, that contract language is not going to be very specific. It's going to be vague. It's going to say something like, we haven't been breached before, and we are taking commercially reasonable steps to make sure that your information is safe. Awesome. But what does that mean? So have this conversation with them. You want to know, what software are they using to obtain the information and the data that they're collecting from you, and how safe is that software? And the reason that matters is, my first thought when I was writing this down, is Google, right? So a lot of people use the Google suite for business, but if you just use the free plan, please believe that Google is scanning your emails and your information. That's how they're able to get the ads to you, which is why you need to know, are they using the paid version? Because with the paid version, it's more secure and you don't get that problem. You don't have that problem. So you want to ask questions, what software they're using. How do they maintain your data? So once they get this information, what do they do with it? Do they print it out and put it in a folder? Do they keep it on a public drive? Is it protected? Why am I stuttering? Is it protected by passwords? Who has access to it? Does anyone have access to it? Those are the type of questions that you want to ask when you're dealing with cybersecurity and just making sure that your data is protected. You want to know, what steps are they taking and what are they doing in order to keep you and your data information safe. And then you also want to make sure that there's something in that clause, in that agreement, that states to, you know, that they're going to make you aware if there is a breach, that they're going to let you know. So that's my take on cybersecurity. Yes, especially if someone's dealing with your sensitive information, what are they doing to keep it safe? But beyond that, you want to just know for yourself, what are they doing? Like, you don't want to just have a clause that says we're taking commercially reasonable steps. You want to ask and inquire what that looks like. So great question. The next question comes from another insider. I just saw it. And it is, if I go back to the next question says, are trademarks for catchy slogans or taglines that your business uses? Hold on, let me read this. Are trademarks for catchy slogans or taglines that your business uses, and are the way the name is used to describe a product or service? Okay, I think this question is asking me if you can use a trademark for your tagline. And if that is the question, the answer is absolutely. If that catchy phrase, let's be clear about this. If that catchy phrase is used to identify the source of a good or a service, then yes, it can qualify for trademark protection. If you're using that catchy phrase in your business as on merchandise, meaning on shirts, on whatever, like mugs, like we have this very cute Own Your Genius mug, you know, which on the other side it says legal tea. How cute is that? But if you're using it for this purpose, like promotional purposes, you know, merch purposes, then the answer is no. So when it comes to short phrases, they're only protected if it's used to identify the source of a good or a service. So think Nike's Just Do It. They use that not only on their apparel, but they also use it in their commercials and in their marketing and in their advertising to help you identify and connect their product to what they're offering you. So in that case, the answer is yes. If it's used to identify the source of a good or a service, then the answer is yes. But if it's just used as a catchy phrase on merchandise, the answer is typically no. Another great question. And you can start dropping your questions in the chat. You start dropping your questions in the chat and we will get to them because we're coming up on our last submitted question. And this one is, what clauses should you include in your operating agreement? And I like this question. And I'm just going to take just a second. So an operating agreement, for those of you who do not know, it is your contract. So when you have an LLC, an operating agreement is sort of like your bylaws before your LLC. When you have this LLC, when you form your LLC and you have members, and even if you're a single member, you want to have a contract that lays out how the business will be ran, how decisions will be made. This is, in my opinion, is specifically are really important for those who are single members. And that's because what that LLC does is give you limited protection. It separates your business liabilities from your personal assets. However, you have courts that will say, well, oh, it's just you in the business. So you're really not a business. You're really not an LLC. You're just pretending to be one. And so they will do what we call pierce the veil, meaning they will not give you that limited liability protection because they say that you and your business are still one, right? So you as the business owner, you have to show that you and your business are actually separate, and you do that, you know, in several ways. That's with the separate bank accounts and the systems and things of that nature, but also with your operating agreement. If you have an operating agreement that lays out how decisions will be made and you're running your business according to that, then it will help your position as far as saying that, hey, I am an LLC. And so some things you want to include in that operating agreement are, who are the members? And so members, so LLC have members, and the members are similar to owners. So instead of saying owners, you have members. So who are the members of this LLC? How will you add new members into the LLC? If you need to terminate a member, what grounds will you have for termination? What does that look like? And then capital contribution. When you first start, like how much money are the members required to put in order to form this business? Because that's another way that LLCs, they lose their limited liability protections because they're not properly funded, meaning that they go into contracts and business arrangements and they don't have enough capital to run their business, meaning they get loans in the business name and they don't have like any money. Like it's literally ran from the members' personal accounts. So you want to say, how much money are we putting into the business account? Whether it's $5,000, $1,000, whatever it is, right? You want to put that into the operating agreement. You want to keep a note of how the records are going to be maintained, how often you're all going to meet, the company's mission and purpose to make sure that you're all staying in line, distributions, so in addition to your salary, if you're running a for-profit business, you're going to have your revenue, then you're going to have your expenses, and then what's left is going to be profit. Are you going to distribute that profit to the members? And if so, how? What does that look like? When? How much? Things of that nature. You want to put that into your operating agreement. And then, like, if you decide to close the business, how are you going to wind it up? What does that look like when you dissolve the business? Those are just a few things that you want to add to the operating agreement. Let's see. Reba says, okay, so those are the questions that we had that were submitted to us. So thank you for those questions. And right now we have Ms. Reba who says, I'm a healthcare professional who is entering into the coaching space. What type of wording needs to be in my contract to clarify that we are not in a doctor-patient relationship throughout coaching? You need to, look, that's something you need to just spell out. No hiding around, around beating around the bush or anything. You need to let them know that this is not, I will put language in there that says something like, by entering into this agreement, you are agreeing that this is not a client-patient relationship. You understand that you're not working with me in, a doctor-patient relationship. And in contracts, sometimes it's just as important to say what's not included as it is to say what's included. So that's one of these things where you will expressly say there is no client-patient relationship being formed by entering into this coaching relationship or coaching agreement or whatever you want to call it. Should you or can you get cyber insurance for a website if you don't have an LLC yet? So for me, it depends on what's on your website. What type of information are you gathering? I don't think like the normal regular person would need cyber insurance, but I will tell you that that's also not my lane. So I would talk to someone about that. But I feel like cyber insurance would be someone that's collecting a lot of data and private information on their website. Like your freebie, so email address. No, I don't see that being, personally, I don't see that being something that you would need to get cyber insurance for just starting off. If you were getting other personal information, then maybe, but email addresses, no. Let's see. And let me see something. You're very, very welcome. And I think this is Stedman. I know that, is this Stedman calling user? That might be Stedman. I know you had some questions, Stedman, and it looks like you're calling in and not on the, on a computer. Okay. All right. Okay. So what is your question, Stedman?
Yes, two. So first question is, I saw a video where I was looking some information up on how to sell your trademark or license your trademark.
Mm-hmm.
And I saw a video where they were explaining how George Clooney created a trademark for a tequila company that he had, and he sold the brand to a some type of major worldwide distillery that makes all types of different alcohol. So I was confused because they said he never sold any tequila before he sold his trademark or his brand to this other company. And with my real estate background, I'm familiar with this because it's very similar to a technique that they call wholesaling, where you're basically creating an agreement and you sell that agreement to someone who actually wants to buy the property. But can you do that same thing with a trademark? So if I created, say it again.
I
Hello?
was finishing your sentence. Yeah, can you hear me?
Oh, right. Yeah, I hear you. I didn't know. Yeah, can you hear me? Hello?
Yeah, I can. Okay. So yeah, let me answer this question. I'm gonna put you on mute real quick and I'm gonna answer this question. So with trademarks, your trademark has to identify the source of a good or service. I said that several times tonight, that you have to identify the source of a good or service. If there's no good or service, there's no trademark. However, what you can do, if you have the intent to start a business, intent to do something, then you can file what's called an intent to use application. Now, I don't know the details of the George Clooney situation. I don't know if he went into it. He started building his brand with the intent to actually start his own tequila company. And then he got approached and said, okay, well, this is a better offer. But yeah, you typically, it's not like the wholesaling of property. It's not like a domain name where you can just get it and then sell it off. Like when you file that application, one, you're saying you're either doing one or two things. One, you're saying that the good or service is in commerce and this trademark identifies it. That's one. Or two, you're saying that it's not in commerce yet, but I have a bona fide intent to put it in commerce, and we're making plans and getting it together to do so. Let's see. I'm trying to unmute you. Okay. Did that answer your question?
Okay. Yeah, it does very, very much. And it's exactly what I was thinking. Like you have to at least have some type of traction going to do that. Now, is it that they're buying the brand, or is it that they're buying the use of the trademark? Because from what I understand, selling the company as a brand would be different from selling the trademark. Is that right?
So you can license. You know who does this? One of the cola companies used to do this, where they would literally just license their name. And so it's not that they're selling the cola company, or he's not selling the tequila brand to the person, but he's giving that distillery permission to put his brand on their tequila, to sell the tequila under his brand. And it's similar to, you know who else does this? NFL does this. The NFL does this. They work with several manufacturers, you know, throughout, and they have, each of those manufacturers have permission to use their trademark.
Okay. Got it. So, am I still there? Can you hear
me? I can hear you.
Oh, okay, cool. So is that similar, like the name part, just doing the name? Is that very similar to the Lady Antebellum case that you sent out? Because I was looking at that. So if I created a name, and this name is to be used, let's say, on a pair of shoes, I can then license that name to other people who have a manufacturer for shoes.
Yes.
Okay.
So yeah, so if you're selling shoes, you can license it out to other people. To maybe they can make shoes, or maybe they can, if you want to get into the apparel or some other field that you're not doing, you can license that name for that purpose.
Got it. Okay.
Yeah, licensing is
All right.
pretty dope. It's ways for you to have revenue without actually being in certain industries.
And that's the struggle I'm running with what we're working on. Because it's way more detailed involved what I'm building than I thought. I'm kind of in over my head, and I'm spending a whole lot of money. So I'm trying to figure out what's an alternative to still using this product, but not going full force with the brand. So it's kind of making me look into brokering, almost like brokering the license with another company or someone who may be interested in using the product in the trademark that
Now,
in the same way that I intend to use it.
now keep in mind that when you license it, you're still control as the owner, trademark owner, you're still responsible and in control of that brand's image, if that makes sense. That's the whole purpose of licensing, is you're saying that I own the trademark, but I'm going to let you borrow it, for these circumstances, these limited purposes. But you as the trademark owner, you're still responsible for all of the goodwill and everything that's associated with that mark. Like, you're not giving that part away, right? That you're not licensing out that part, because if you were, then you would
Mm-hmm.
run the risk of losing your trademark.
Could you still do that? Let's say if you wanted to just license it in even the business, or would you have to still? Like, is there some type of negative ramifications for not maintaining it or selling the entire thing?
Oh no! If you want to sell the trademark, then sell the trademark. That's something that you can do. But the only thing is
Okay.
that you're selling it, so you're not getting anything from it. You're like
Mm-hmm.
saying, "Hey, this is yours now," and then you have no say so over
Right.
anything.
Right.
Mhm.
Right.
And if you need to,
Okay.
Stephen, just go into the dashboard and then just schedule a one-on-one.
What's it called?
Your dashboard, log into the Genius Lounge and just
Uh
schedule
huh.
a consultation.
Okay. Yeah, I didn't know. I knew that, but I just, a
Yeah,
lot of things going on. So,
that
well,
way we
okay.
can go more into depth with what you're doing.
Okay. Perfect. I'll set that up. Thank you.
Cool. You're welcome. You're welcome. Let's
Thanks.
see. And then we have another question that says, if you are a startup, at what point do you recommend getting an LLC? Does it depend on the type of business, or is it when you get to a certain profit level or something different? Ooh, I like that question. And that's actually the podcast that was supposed to go out tomorrow, but it's not going to go out to Thursday. We are going to talk about choosing the right business structure and when you should make that happen. But the point, I recommend you getting an LLC. First of all, making sure that that's the right business structure for you, right? And there's different things that you want to consider. You want to just start out with your goals. And when you're thinking about different business structures, excuse me, you're going to take in consideration things like, okay, how many people are going to be owners of the business? Are you going to be a single member? Are you going to have partners? Are those partners real partners where you're 50-50? Or are those partners, are you going to have a partner that's just like in name only because they're just funding the project? Things of that nature. Is there going to be a point where you're going to have to, or you're going to want to raise capital, because those things are going to dictate what type of business entity you're going to get, right? And if you choose the LLC, you want to choose that one before you start entering into like providing your good or service, simply because that limited liability. You want to go into business with that limited liability. You want to enter into these business relationships and contracts with that limited liability. Just making sure that that's there. So that's what you want to, let's see. Ah, look at that. I've been trying to do that the whole time and it didn't work. Anywho, so you don't have to wait till you get to a certain profit level, because if you wait till you get to a certain profit level, you also get into a certain level of exposure and liability. The more people you work with, the more chances it is that someone's going to be like, "Ooh, I don't like this. I want to sue you." So you want to make sure that you don't have that problem. But you also don't have to get it too early either. meaning that you don't have to get an LLC. As soon as you have a business idea, you don't have to go out and get an LLC. Like I said, go through, work it out, make sure that's the right business structure for you. And then if you're still in the planning and building phase, and you're not working with third parties yet, you can hold off, because here in Alabama, once you form that LLC, they're going to hit you with that business privilege tax right off the bat. Like, hey, I'm so glad you have a business. Give us money. And if you're not there yet, then you can hold off. Now, your LLC is not the same as the trademark. With your LLC, you can wait until you're entering into those agreements. With that trademark, once you have your idea and you've done your business plan, and you know that, okay, this is how we're going to move forward. I know this is something that I want to do. This is the right name. Then you want to go ahead and file an intent to use trademark, so you can have that protected. So at the end, when you launch, you don't have to worry about your trademark being taken by someone else. Let's see. Diana says, hey, let's talk later regarding how to connect the Murray's Law sessions through the Genius Lounge. Cool beans. Hey, let me ask the people that are here in the Zoom call. Were you able to connect straight through the Genius Lounge, or did you have to go through the Zoom link? So Andrew says Zoom. Well, yes, you went through the Zoom or through the Genius Lounge. I mean, you're in the Zoom call, but the Genius Lounge, you should be able just to click the button, the thing in the Genius Lounge, and it just opened up the Zoom straight from the lounge. That's how the tech is supposed to work. But I know, like, we have one member who always, like, we can't get her in through that way. The lounge button. All right. So what we'll do, Diana, we'll walk through it. Like, we'll set up a sample one, and you'll just walk me through what you have and share your screen so we can see what's going on, because you should be able to. And then Adele says she got the login information for the Genius Lounge, but she had to. Oh, what browser are you using too? That might matter, but we'll figure that part out. But what browser? Genius Lounge. Okay. Cool beans. Well, we have a few more minutes. Are there these questions have been great? Do we have any more questions? And while I'm waiting for questions to come through, I'm going to tell you, make sure you guys join us on the last Thursday of this month. We have an amazing speaker coming through. I'm really excited to have Emerald Spark. She is an accountant. She has a membership group, and she's really helping entrepreneurs take control of their revenue and their by their pricing. Like, that's one of her main objectives, is like teaching people how to price their things properly. And she's going to come and share with us, and I'm excited. Like, her program is called I Charge What I Want To. And so she's going to talk to us about how we can do the same. And the reason I felt like it was important for us to have this conversation is because that's one of the main questions I see all the time. Ooh, how much should I charge? I don't know. Will people pay this? Yada, yada, yada. All these things that we have. So that's going to be a really great masterclass. And so for the Genius Lounge members, you can watch it. You can join us live, 7 p.m. last Thursday of the month. The replay is only available for our insiders. So if you're not an insider yet, what are you waiting for? What are you waiting for? That's all I want to know. What are you waiting for? And yes, Andrea, it's going to be great. I'm excited. I'm looking forward to it. All right, let's see. Cool beans. So if there are no more questions, let me go back. I'm excited that I was actually able to see. Okay, let's see. Stepman, you had a question?
Yes, it's a quick one, easy one. As far as like language, and when you're applying for trademarks and stuff like that, what is the term streetwear? What does that include totally? Like, does that include hats, or does it just include shirt and pants? Like, what does streetwear include? That word specifically?
It's more of like the apparel part of it. So it's not the hats or footwear or anything of that nature. It's
Okay.
referring to the
So if
type of
you're applying
apparel.
for a trademark, right. So if you're okay, so it refers to the type of apparel. So streetwear is not the same as formal wear, which is obvious, right? So
Right.
footwear would have to be specifically spelled out as to something that is going to be used for that's in that trademark. You can't say that we're going to use footwear uh, to consider that to say that that's streetwear as well.
Correct. Like if you're gonna sell shoes, then you need to let them know that you're selling shoes. Because that's even with
Got it.
formal wear.
Okay.
Even with formal wear is more towards the apparel, not necessarily shoes. You might have formal shoes, but when you're talking about formal wear, you're talking about tux and gowns. You're talking about the apparel part of it.
hmm Got it. Okay. Thanks.
Cool beans. All right. Well, ladies and gentlemen, that has been our last question. You all have been awesome. We will see you the second Monday in August. Can you all believe, first of all, and actually, I'm trying to think. Yeah, we're definitely going to see you second Monday in August. But what I want to do is have a like a Genius Insider member spotlight. And so you all can email me and let me know what you think about it. And yes, same time. So our guest speaker will be Thursday, 7 p.m. Central Time of this month. And there'll be a reminder that goes out. And then we'll do this again second Monday in August. But I want to do like a member spotlight because there's so much talent in our group, and I want you all to know one another. So I want to do maybe like an interview session, and maybe I send out an email where you all will let me know if you'll be interested in coming in and letting me, telling the group about what you do, providing some useful information and things of that nature. Or maybe we'll do like a virtual happy hour, like a networking thing. I don't know. I just know that we have a lot of talent in this group, and I want to be able to connect everyone. Cool beans. Well, that's all I have for you all. I will talk to